Hello, everyone. Hope you and your family are healthy and safe during this uncertain and unprecedented times. My name is Pratik Nilkund, and I'm a business analyst working with Royal Cyber. The objective of today's presentation is to provide an overview of CCPA, or the California Consumer Privacy Act, and a high level overview of our solution design to support legal compliance. We would also, during these testing times, like to focus on helping the community and support businesses by offering 1 month of complimentary services, the details of which are outlined in our closing slides. Let us now quickly get introduced to CCPA. Well, the digital world was shaken up on June 28, 2018, when the CCPA of 2018 was passed by the state legislature. Following in the footsteps of the GDPR, CCPA brings data privacy efforts into US legislation. Now, CCPA, simply put, outlines new standards for data collection, new consequences for businesses that fail to protect user data, and new rights that California consumers can exercise over their data. In effect, since Jan 1st, 2020, businesses are now subject to comply with the CCPA. So let us look at who needs to worry about CCPA compliance. CCPA applies to for-profit businesses that do business in California, collects or receives personal information of California residents, and meets just one of these three categories, which are: has a gross revenue of over $25 million, collects personal data for 50,000 or more consumers, or obtains at least half of its annual revenues by selling consumers' personal data. Now, category 2 is likely to capture any company that conducts business online or through a mobile application. So let's move on to provisions under the CCPA. Probably the most obvious right that consumers have under the CCPA is the right to notice. Under the CCPA, businesses must inform consumers what categories of personal information will be collected and the purposes for which these categories will be used. The law empowers Californian consumers to request a record of what personal information is being collected about them and the purposes for which the personal information is used. Now, consumers also have the right to request deletion of personal information. It is here that companies have to determine the expectations of their particular consumers and follow the information trail to process the request. Now, consumers have the right to stop the sale of their personal information, also known as the right to opt out. Businesses have to put a special "do not sell my personal information" button on their websites to make it super easy for consumers to object. Now, the CCPA also prohibits businesses from discriminating against consumers by denying goods or services, charging a different price or rate for goods or services, or providing a different level of quality of goods and services. Let's move on to why companies need to take CCPA seriously. The law allows consumers to sue companies for non-compliance with fines of up to $2,500 per violation or $7,500 per intentional one. To put this in perspective, a CCPA violation affecting 10,000 California consumers can result in a penalty of $25 million for an unintentional violation or of up to $75 million for an intentional one. And that's why companies should take it seriously. In a world where data is the most valuable resource, with media outlets covering more data scandal stories than ever, consumers are increasingly more aware of data collection and how it affects them. GDPR and CCPA are two of the first regulations to protect consumer data. It's widely anticipated that more companies or more governing bodies will implement privacy and consent regulations with heftier consequences for non-compliance. With this in mind, organizations need to be prepared and covered. Therefore, Royal Cyber has developed a 12-point reference architecture for supporting companies to be legally compliant. Let's glance through each one of them. Point number 1: develop data privacy policies and standards. Now, it's quite possible that few users will ever read your entire privacy policy. You may ask yourself, is it truly necessary? Well, to put it simply, if you collect personal data from users, a privacy policy is required by law. The general purpose of a privacy policy is to inform users exactly which personal information is gathered by your site or mobile app, how it's used, and how it's protected. At some point, you will probably want to get in touch with your customers and they may want to get in touch with you. Therefore, it's always necessary to include a communication clause. Other inclusions are listing methods of collection and usage, future changes to privacy policy, third party details, etc. We help make internet a better place by following some really simple best practices when writing your privacy policy. Point number 2, implement data sharing agreements. Now, data sharing agreements are formal contracts that details what data are being shared and the appropriate use for the data. Now, data sharing can also be really complex, and this is why it is must to carefully draft a data sharing agreement to ensure that your organization is compliant with applicable privacy laws and the proper safeguards are in place to protect your information. Now, some of the questions that need to be asked here are: who are the parties that will be collecting, using, and disclosing data? Now, why is the data being shared between the parties? What information is being shared? What are the data elements, data sets, and time frames? How will data be shared between parties? Also, what is the frequency of data transfer? It's important to note that data sharing agreements should be drafted for data movement within company or outside of the company. Moving on to the next point, data retention and destruction controls. CCPA sets up additional requirements around retention of personal data compared to Data Protection Directive. Given that breach of these provisions can lead to the imposition of considerable fines, data retention is not simply a matter for IT and administration, but a business consideration with potential impact if you don't get it right, especially financial. It's important to have a checklist when implementing a data retention policy that documents where personal data is stored in the company. The general retention periods are on a case by case basis, and decisions around what to do with data after the expiration of the retention period. For example, should data be anonymized or destroyed, and all the policies that revolve around them. Data masking hides data elements and replaces them with similar looking fake data, whereas data encryption involves transforming data into scrambled ciphertext with algorithms. It is necessary to employing these data masking and encryption standards in order to make your data truly secure and at the data level. Now, it's important to note that daily business and technology operations, such as loading data to test environments or maybe migrating data to advanced systems, call for data masking and data encryption methods that need to be standardized and made not only transactional but reusable across the enterprise. This brings up a very important point, which is security controls. For example, at a management level, security control is about providing guidance, rules, and procedures for implementing a security environment. Whereas at an organizational level or an operational level, security control includes access control, authentication, and security topologies. Whereas at the lowest, which is the physical level, security control deals with threats, physical threats that could impact the confidentiality, integrity, or availability of systems or data. Point number 6 is data protection and impact and assessment. Now, a DPIA or data protection impact assessment is required when processing is likely to result in a high risk to the rights and freedoms of individuals. A DPIA is required at least in cases where there is an extensive evaluation of personal aspects of an individual, processing of sensitive data on a large scale, or monitoring of public areas on a large scale. For example, DPIA is required for a bank screening its customer against a credit reference database or a hospital about to implement a new health information database. However, a DPA may not be required for a community doctor processing personal data of his patients, since the processing by the community doctors isn't done on a large scale. It is also important to conduct a vendor risk assessment. Now, given the current economic climate, many companies are looking to trim the fat and focus on only core specialties. Corporations are outsourcing key functions to third party vendors or suppliers, ranging from, say, accounting tasks to manufacturing to packaging. This practice is effective in that it can essentially reduce costs or enhance performance. While this practice may ease some tedious functions and enable the business to excel at what it does best, it also opens companies up to various risks through actions of these third party vendors. Therefore, it's necessary that companies research a supplier or vendor before signing on with them. Companies should know what they want out of a partnership, and the contracts should help them achieve these goals. There is also a need to keep a backup plan which will help mitigate any risks. Well, what do you mean by records management controls? Simply put, it is necessary to have records management, which is a system that controls an organization's records from the creation of the record until the record is archived or destroyed. It is necessary to have a framework set up to increase business efficiency, reduce risks, and most importantly, ensure that your official public records are in safe hands and are properly managed. Well, it is also important to implement breach notification controls. The most common privacy breaches happen when personal information of customers, patients, or clients is stolen, lost, or mistakenly disclosed. Now, a successful breach notification plan encompasses more than just a method for promptly notifying the victims of a security breach event. To be effective, the breach notification process must be a part of comprehensive information security plan, and uh, it should have some important components like risk assessment, trigger events, and mitigation plan in place. Point number 10 is establish data discovery processes. Well, historically, data discovery has existed at the nexus point between data preparation and analytics. The discovery process was frequently viewed as the means of gathering the requisite data for analytics while illustrating relationships between data elements which might inform them. Today, data discovery's utility has considerably broadened. Data discovery is playing an increasingly pivotal role in enabling and solidifying data governance for today's highly regulated data environments. So, the first step of this data discovery process is to gather the right data in one place. Data may also be scattered across so many sources, must be placed in a single area where all the analysis can take place. Now, raw data imported from different sources can rarely be analyzed as is. So data also needs to be clean and structured in ways that makes it reliable and robust for analysis. It's important to note that uh, data can be shared to different departments for different purposes. For example, a statistician or a data scientist will analyze different aspects of data, whereas an auditor can check for how compliant are you to a particular regulation based on what data have you stored and where. Um, Now, once you've discovered data, it is important to complete data mappings and lineage. Now, data lineage can loosely be defined as a description of the pathway from the data source to the current location and the alteration made to the data along the pathway. It is important to note that data governance requires metadata management. Multiple different stakeholders, including customers, staff members, and auditors, need to trust reported data while quickly responding to business opportunities and regulatory challenges. Tracking data lineage, therefore, provides proof that reports properly reflect the data. Data maps document relationships between data and applications within a business process, or to data stores or databases in an environment, and also network segments, especially for reasons security. Let us look at how data lineage looks. By the way, this lineage is designed on our partner tool OneTrust, a privacy management platform, and it has capabilities to make help companies be legally compliant. Point number 12, and also the last point, is to manage data subject access requests. Now, data subject access requests give individuals the right to discover what data an organization is holding about them, why the organization is holding the data, and who else their information is disclosed to. Timely responses to DSARs are not only required by CCPA and GDPR, but are critical to building trust with your customers and potential customers. By showing what you're collecting, who you are sharing it with, and why, and where you keep that data, you build trust with your customers. Let us look at a few steps to undertake on receiving a data subject access request. Firstly, companies need an easy way to receive, log, and authenticate the DSAR and to automatically notify the person and company leads. The second step is to assign and manage the collection of information, usually from multiple data stores with multiple owners or managers. Then, it is necessary to review the request and the personal information and also ensure that you are delivering what is required to the right person. Finally, personal information needs to be delivered to the right person in a secure way. Now, it's important to remember that using existing email or document management systems to manage customer data require requests. It brings about huge security risks. So you don't want your customer data floating around in your systems. That is why we leverage the capabilities of many tools like IBM, Informatica, ServiceNow, and Atlassian in our efforts to make companies legally compliant. As mentioned in our opening slide, we are here to help you through the COVID pandemic and have rolled out 1 month of complimentary services. During this time, our group of experts will configure tools to your environment and provide a training for these tools. We will also help in assessing the as is compliance state and where you need to be to govern your organization better, not only for compliance purposes. Of course, that's a major part of it, but also to dramatically boost operational efficiency. If you are interested or would like to meet us virtually, feel free to drop us an email on info@royalcyber.com. Also, don't hesitate to check out our website, www.royalcyber.com. A big thank you for hearing us out today. Stay healthy and stay safe. Thank you.